Okay, before I jump into this video, for those of you who know my chaotic world, today I have my sister's pup with me as well, so there will be chaos in the background of my video. I apologise in advance. Now, the document that I'm going to cover in this video, I will be uploading it to my Patreon. I will also be uploading the emails that I went through yesterday. I'm still working on putting watermarks through them and putting them into a single document because, as I mentioned in yesterday's video, the real estate stuff has Stefan's address on it, which just happens to be Chris and Deb's address, so I don't really want to be publishing that. So if you're watching this, you're probably aware of the 70 plus motions filed by Stefan's lawyers, and this week there's been a response from the prosecution. They have filed something like 30 documents which are responses to the motions that have been filed. I am going to do videos on these. Mostly I'll be looking at them in groups of motions, and you'll see that as I get to it. But I wanted to address this response on its own, because this was possibly one of the most despicable motions filed by Stefan's team. And clearly the prosecution thought this was pretty despicable too, because despite having several quite capable attorneys on their team, they handballed this one straight to the top, and the response is actually from Will J. So what am I specifically talking about here? This is that motion that was filed by Stefan's team to allow victim impact statements from his parents saying how it would affect them were he to be given the death penalty, totally taking the focus away from the victim and putting the focus on Stefan, which to me is just utterly sickening. So I'm not going to go back through the original motion that was filed by Stefan's team. Their motions are pretty wordy, pretty tedious, and usually full of misinformation in that they don't seem to be able to find the right statutes or the right precedents to support their cause. So I'm going to just jump straight into the document from Will J and go through that. Now, before I start, I'm just going to ask for you to please hit the like button. Right now, my videos, my Madeline Soto videos, are really struggling. There is a reason why. Many of my regulars know the reason why. I don't think we need to go into that today. But I'm just going to say I will not be bullied into stopping covering this case. Take that how you will. So you can help me out by hitting the like button. That will get these videos out into the algorithm and seen by more people. And if you are new to my channel, please subscribe. That will also help me out immensely. So on that note, let's just jump straight in. So this is State's response to defendant's motion to allow testimony of the impact of defendant's execution on family members. Utterly despicable. And honestly, I hope the judge actually makes comment on this, gets something on record in terms of how utterly despicable this is. Argument. The United States Supreme Court has held that to be constitutional, the death penalty must allow for individualised sentencing and must allow consideration of any aspect of the defendant's character or record and any of the circumstances of the offence that the defendant proffers as a basis for a sentence of less than death. Florida law is clear that mitigating circumstances are those circumstances listed in Florida statute specifically or are relevant to the defendant's character, his prior record, and the circumstances of the offence. Note here, there's nothing here about his parents. Specifically, the Florida Supreme Court has ruled that the trial court does not abuse its discretion by refusing to allow testimony of the impact on the defendant's family of his potential execution. Burns v. State. The defendant sought to introduce testimony about the impact his potential execution could have on his family members, arguing that such evidence was relevant to his character and background. After the trial court sustained the state's objection to such testimony, the trial court allowed the defendant to proffer the testimony of the defendant's sister and 2 daughters as to the effect his execution would have on them and their family members. The Florida Supreme Court held, while we agree that Burns' family relationships and support he provided his family are admissible as non-statutory mitigation regarding Burns' character, this was not the focus of the proffered testimony. The proffered testimony went to establish that death was not an appropriate penalty because of the impact of the execution would have on Burns' family. We find the trial court did not abuse its discretion in excluding this testimony concerning the sentence Burns should receive. So what they're saying there is that while they were happy to accept testimony from Burns's family with regards to his character, they were not going to accept testimony which was going to say how his execution would impact on his family. So basically, that testimony was excluded because it did not fall under any of the categories which were listed in terms of things that could be proffered for mitigating circumstances. And it seems that since Stearns' attorneys like to cite multiple precedences, Jay has done the same thing. See also Thompson v. State, upholding trial court's decision not to allow certain defence witnesses to express personal opinions about the appropriateness of death penalty. A significant number of other jurisdictions have ruled likewise. And normally I don't read through all the precedents, but I think these are quite relevant. So you've got Woods v. State, upholding trial court's decision finding that evidence regarding the impact of the defendant's execution on his family member did not relate to the defendant's character or record or the circumstances of the cases and was therefore inadmissible. State v. Chappell, holding that evidence of the impact of the defendant's execution would have on his young daughter and other family was not relevant mitigation. People v. Vieira, holding that testimony from the defendant's mother that his execution would destroy her was properly excluded. And we just get more of the same. So having proved his brilliance with half a page of precedents, Will J continues with his argument. Defendant cites to Lugo v. State in support of the admissibility of such evidence. It is important to note that in Lugo, the issue as to the admissibility of such evidence was never litigated. Instead, the challenge on appeal focused on whether the trial court properly weighed such evidence. The court in dicta stated while the impact that Lugo's execution would have on his mother and children is properly cognizable, it nevertheless does not outweigh the aggravators attached to the murders of Grieger and Furton. The proposed testimony as to the impact defendant's execution on his family members does nothing to inform the jurors concerning the defendant's character, his record, or the circumstances of the offence. The testimony should be excluded because it is irrelevant and because of its prejudicial effect and lack of probative value which cannot be properly rebutted. The state agrees that defendant should be entitled to introduce evidence regarding the positive character traits that his family members cherish. However, to allow defendant to tie those positive character traits to sympathy toward the family members if defendant was to be executed is contrary to Florida Supreme Court case law cited above. Wherefore, the state requests this court deny the defendant's motion to allow testimony of the impact of defendant's execution on family members. And then copy filed with Elizabeth E. Borden, Lizzie Borden. So, I can't help myself, I'm sorry. So this one is of course short but sweet. But I did want to address this one on my own because to me it was something that really, really ticked me off. That they would even have the gall to suggest such a thing. And let's not forget that his parents, as far as I'm concerned, played quite a significant role in him ending up where he is today. Because they spent his entire life enabling him. And if it is true that Deb Stearns was buying people off to keep them quiet, then she owns a lot of this. So we don't want to hear from them about the impact that his death is going to have on them. That's got nothing to do with Maddie, and it's got nothing to do with justice for Maddie. So on that note, thank you for listening. As I mentioned at the start of the video, please hit the like button. That helps me get this video out into the algorithm. It gets more people seeing it. Also, please subscribe if you are new to my channel. And of course, please leave a comment below. Thank you, and I will catch you in the next one.